Okay, so let's get some more practice researching codified law, in this case, court rules. Realize that when you're researching codified law, oftentimes you have to piece together multiple sections. So as an example, look at the answer here to this issue, which I've put under codified law right here. You can see that there are at least 3 codified law clauses or sections of the court rules that we have to read together. And then there's actually a couple more, this Rule 5 about service, and then the Rule 6C3 about modification we need to read. And then Rule 7 just about motions in general, how they have to be written and things like that. So we have to read all of these sections together. So I hope you're not throwing too much hate my way, but this is real life. This is why researching is so hard, because we have to read all of these things together. Okay, so here's the answer, and we're going to need to read these basically in this order. So it's going to go C or 6C2, 6C1, and then 6A. And let me show you how to find that. When you're researching the court rules, like if you use the official version, you'll get this. You'll click on Rules of Civil Procedure. That will give you this PDF, and then it starts with the table of contents. If you did a search engine in Westlaw or Lexis, you're going to find these anyway. I prefer the table of contents method just so I can get some context for what the heck's going on. So I can quickly see here that Rule 5 about service, Rule 6 about time, and Rule 7 about motions, that's going to be pretty much my home court. So I'm going to click on here the rule for time, and I'm going to read this in the order that I think logically makes sense. So that's under 6C2. Right here it says that a written motion for purposes of a hearing that is not a trial, that's us, shall be served no later than 14 days prior to the hearing. Okay, so 14 days prior to the hearing. That's for the moving party. Now for us, the question is really about us. When do we have to respond to it? We have to respond also within 14 days after service of the motion. Okay, so the moving party has 14 days before the hearing to serve it, or they have to serve it 14 days before, and then we have 14 days after that point to file our response or serve our response. And then the third provision up here is how do we compute the time? And it makes it very clear here that the day the act or event, so that would be like the hearing, from which the designated period of time begins shall not be included. That's kind of the main rule for us. There are other rules here, but this one really applies to us. So we need to read all of these things together. So then looking at our calendar, if the hearing is on May 14 and the court rule says that it's 14 days before the designated event, then we don't include the actual designated event. So that means we do not include May 14. So we would count starting the day before. So May 13 is day 1. So if we go all the way back 14 days, we land on April 30. And that Rule 6A says that you do count the final day in your count. So we do count April 30th. So the moving party, they should have served the motion 14 days before the hearing, which should have been April 30th. So they didn't. So they're in violation of the court rules. So technically because of that, we could have the hearing moved. Okay, so that's number one, is they did not serve it within time. Now let's assume they did serve it within time, so they served it on April 30th. In that case, we would have 14 days from when they served it to file our response. So then we would have 14 days, so we would count that by starting not on the designated day. So we don't count the designated day, which is the 30th. The service is the designated day. We would count starting on May 1. So we would land on May 14. So our response, if they had served us correctly, our response would be due on May 14. Now, because they actually served us on May 6th, then we would count from the 7th 14 days. So if we go on when they actually served us, then the answer would be May 21st. All right, see you back in the book.